Thank you so much. Hello, everyone. My name is Frank Partnoy. I'm on the faculty at Berkeley. And we designed this panel to follow immediately after the judges to write a memo live for all of you about whether to leave Delaware. And the answer from a few conversations this morning that I had with a number of you is no, stay in Delaware. But we're going to talk through some of the nuances of that, and hopefully you'll get some embroidered details about what some of the exceptions might be. I think we just saw from the three esteemed jurists in Delaware exactly why it is that people think so highly of Delaware and its courts. So I'm thrilled to be able to introduce this panel. You have the details of their bios, but we'll be getting a unique perspective that I'm especially happy to have from Lenin about the insurance industry. You've been a GC in various contexts and can talk to us about brokerage of these contracts and consulting these contracts. Christina is the founding partner of Cooley's, and I should say for Woodruff Sawyer. We give you a little plug. Christina is a founding partner of Cooley's Chicago office and has been asked this question many times about Delaware and other states, and will be able to give us that perspective. I'll introduce Paul next because that's the order that we're going to go in. But Paul is we always save Jeroen for last. If those of you who know Jeroen, we have to give him the cleanup spot. But Paul is going to give us the Delaware perspective as a practicing litigator before the courts from young Conaway. And then Jeroen from Bernstein, Litowitz will talk to us about many of his cases. He was the star of the panel last year, and I'm sure will be the star again. Or we'll try anyway. So we're going to draft a memo. We're going to write a memo, and Lenin, you're going to help us start out with where? Where?
Yeah, that's a question we're getting, Christina's getting, right? So to give you sort of the lens, I was in-house for over a decade, and then now insurance brokerage side for 4 years. So the lens I'll give is D&O insurance, and I think that is a factor in terms of incorporation. The question we're getting is late-stage private companies, existing public companies, where should we incorporate now that the sort of the dynamic has changed? I think the simplest answer is it shouldn't be the driving force of your decision, because there currently are no state discounts for where you incorporate, at least from a D&O insurance perspective. When we think about insurance carriers, they're very focused on historical trends and data. And on the panel earlier, there was a lot of discussion about data. And so without that, there really isn't much in the way to move the needle in terms of premiums. So until that time, I think what we're seeing more so is it's a bold move to reincorporate, at least for purposes of a press release. But in terms of actual loss modeling, it's less so.
Can you talk us through why that is and what factors might cause D&O premium to change? Like we don't get the opportunity to talk to you, so we really want to take advantage of this as much as possible. So talk us through what would matter if this hasn't mattered.
Yeah, so I think when you think about either IPO companies who within the first 3 years, right, more likely to get sued than more mature public companies, or just even public companies, the biggest driving factor is securities class action lawsuits, precipitous stock drops, and then derivative claims. And so we, as insurance brokers and even the carriers, focus a big part of the analysis for loss runs or determining how much coverage you should get based on that information. And if you look at Nevada or Texas, I think the water's warm, but it's hard to tell for how long, right? I mean, we just don't have the data set in order to determine how our securities class action lawsuit's going to play out there. And so I think that's an important factor. Over time, I suspect it's something that the carriers are monitoring. So over the next 1 or 2 years, I mean, there are clients of ours, right, that have made the move to reincorporate. I think I've been tracking it. There's about 5 or so IPO companies that incorporate in Nevada. I think all eyes will be on them, especially for the IPOs, right? Because those tend to be on the radar of plaintiffs' firms more so than the mature ones earlier.
But no discount for them.
No discount. No.
Does that seem right to the three of you?
Yeah. It does.
Go ahead.
I was going to say no. I don't think it.
The reason companies are choosing to move to Nevada is because of what they believe is going to be a more favorable litigation landscape, less subjectivity in the review of fiduciary claims. And so I think when you take that into consideration, I do think there should be, and I think over time will be some discount, but I agree, we just don't have enough data yet to really satisfy the carriers.
What I would say is if you listen to Lenin's risks that he's identifying that the premiums are based on, the risks are really federal securities claims. He's talking about Section 11 claims. He's talking about, derivative tag-alongs, which are, kind of meaningless and mostly strike suits. And I say this as a shareholder lawyer. But those types of cases are not necessarily driven by the state of incorporation. Those are federal claims. So I would be surprised if you get a discount on those types of claims, depending on where you're incorporated.
If there were insurance just for state claims, if I went to you and said, I just want that, would you give me a discount for that?
Just for
moving
state
for
claims,
Nevada?
it would all be...
We're pricing it right here as you speak, right?
I think it'd just be all subsumed under D&O insurance.
Yeah,
It wouldn't be carved out. I mean, we'll probably get to this later, but I think arbitration is sort of the new factor, right? I'll save that for later.
Okay, well, we'll get to arbitration for sure. So,
Yeah.
Christina, give us a sense of, so you have a bunch of people who are coming to you with this question. They read the newspaper, they see Nevada, Texas. Tell us if those are the two big ones or if there are others. But tell us about those conversations, how they're going, and what you're advising people with respect to which state, where.
Sure. So I think as a starting point, Nevada and Texas certainly are the jurisdictions we're talking most about. And I would say we have seen a lot of movement for companies, when we talk about the category of companies for which this might make sense. But Nevada seems to be the prevailing jurisdiction. I think the data I saw most recently, this year, there have been about 25 redomicile transactions into Nevada and 4, maybe 5 into Texas. And I think for the IPO companies that we see that are considering this as part of their IPO process, that those will lean significantly toward Nevada. Now, who are the companies for which this potentially may make sense, or companies that are seriously considering it? As a general matter, when I'm talking to companies, if they don't have a controlling stockholder, we can talk about it as kind of an intellectually curious conversation, but it is typically not something that I'm advising is, a necessary or advisable step for non-controlling companies. For companies where there is a controlling stockholder, and really the class of companies where this question is coming up time and time again is dual class, founder-led and controlled, primarily tech companies. And for those companies where the stockholders have already sort of been willing via a vote to give those founders, the kind of visionary founders, the control rights of the company, the argument is, for the protection of their board, for the protection of those controlling stockholders, they would prefer to be in a jurisdiction where business judgment rule is codified, where there is not question around what the standard of review is going to be. And obviously we have SB 21 in Delaware. We haven't seen it work its way through the system yet. I mean, we don't even know if it's constitutional, but let's set that aside for a moment. And I think there continues to be a lot of anxiety around how those transactions would be viewed and may be viewed in the future in the Delaware courts. There's another class of companies that I find a bit interesting where we're starting to see this trend play out as well, and those are what I would refer to as the, nano companies, I think I saw somebody, but like small public companies where they're viewing it as just an economic decision. Pre-revenue biotechs, really early stage companies that are in the public sphere for one reason or another are thinking like, okay, franchise taxes in Delaware are substantial. There isn't really a franchise tax regime in Nevada overall. Generally, fees are a lot lower to incorporate there. And even in the last month or two, there have been 4 or 5 companies that fall into that category that have reincorporated, and there are not necessarily controlling stockholders, and the view is that this is just an economic decision. I don't think that is going to really necessarily take off or where we see the trends, but I think it's kind of an interesting side story to all of this.
So there's always been this notion that if you're a small company, your startup, you might incorporate in your home state, for example, or somewhere other than Delaware because it is more expensive. But can we pause just a second and talk about the categories of company that's coming to you that has a controller that's asking? Could the other panelists just sort of react to that? Paul, you're our Delaware expert, and can you give us a sense of, these are, by the way, these are companies that are incorporated in Delaware.
That's
who are
correct.
coming to you and asking about whether they should leave.
That's right, and I think that's both on the pre-IPO, late-stage private companies that are considering a public exit path and want to be public, as well as existing public companies. Tempest AI is an example of a company that we represent that recently re-domiciled from Delaware to Nevada, once public. And we can talk a little bit more about that, but I think those are the categories of companies where we see this.
And just to be clear, Paul, before you give us your thoughts, the numbers are overwhelmingly Delaware. Even this year for IPOs, over 80% are choosing Delaware, notwithstanding all the Michigas.
That's right. I think the numbers are still, approximately or almost 70% of Fortune 500 companies are incorporated in Delaware, and approximately 80% of companies who IPO'd last year chose Delaware as their state of incorporation. It looks like similar numbers coming out this year, although we've got a few months left to see. And I think that there are a variety of reasons for that, but one of the reasons is there's a lot of people within Delaware, a lot of people and institutions within Delaware that work hard every day to ensure that Delaware maintains its status as the place for incorporation. Three institutions in particular. First one, of course, the Court of Chancery, who we heard from three of the judges from the Court of Chancery earlier. And as many of you probably know, the court is a court of limited jurisdiction. So it only has jurisdiction to hear cases in equity, meaning such as claims for fiduciary duty. Cases where there's a request for equitable relief, such as an injunction or specific performance, and cases where the court has been specifically delegated jurisdiction pursuant to statutes, such as cases arising under the Delaware General Corporation Law. And Delaware has a rich body of a case law that's been developed and consistently applied over the past 100+ years, from which transactional planners like Christina can assess risk and plan out transactions. And Christina mentioned Nevada's codification of the business judgment rule. Well, the business judgment rule was principally created by the Court of Chancery over several decades, and it remains the centerpiece of Delaware corporate law. Under clear Delaware law, there's a strong presumption that in making a business decision, directors of a corporation acted on an informed basis, in good faith, and with the honest belief that the action taken was in the best interest of the corporation. And as we heard earlier, the Delaware courts apply the business judgment rule on a regular basis. And they often dismiss cases where the plaintiff had failed to rebut the business judgment presumption. I think Chancellor McCormick mentioned earlier that 10 of the 11 cases, Caremark cases over the past year were all dismissed. There are several control and stockholder transaction cases that were dismissed at the dismissal stage in the past year. So it's a common thing for the court to apply the business judgment rule that's been around in Delaware for decades and defer to the business judgments of the boards of directors. It's true that Nevada has codified the business judgment rule, but that too is a presumption. And so that means that you still need a court to apply that statutory standard to the given facts of a case. And I think that, in Delaware, so both Delaware and Nevada, you have a rebuttable presumption. And the difference is that in Delaware, you've got a court that has expert judges that apply decades of precedent, whereas in Nevada, you don't have that.
It's coming.
It's uncertain still, though, because it requires a constitutional amendment, and it needs, I think, to pass a vote of the legislature again in 2027, and after that, it needs to go for a vote of the residents of Nevada. So, in my view, it's still uncertain, and even if it is coming, it's probably not until 2028, at least.
And you interrupted and said it's codified sort of facetiously, but let's talk that through, because we live in a common law world for the most part, and people who do business are used to the kind of Holmesian notion of the law being a prediction of what a judge will do, a prediction of what one of those three smart judges will say, but it's not codified. So what do you get out of it being codified? I have a bunch of students here. Would it be clearer if it were written down in a statute, or is it better to have hundreds and hundreds of cases that explain exactly what it is that happened in a particular context? Seems strange. So what did you mean when you said but it's codified? Talk us through that.
The Nevada courts have sort of expressly stated, and the legislature has expressly declined to codify any higher standard, entire fairness in particular. And so, well, yes, it's still a rebuttable, presumption. Having it in statute, I think, is an initial matter, very meaningful. There's also additional, law in Nevada around very limited fiduciary duties of controlling stockholders. I think more clarity around who is a controlling stockholder in Nevada, when read together, generally view that it is unlikely, absent some fairly extenuating circumstances, that there is going to be some heightened standard of review, or it's going to be very hard to rebut the presumption, I guess is sort of how I'd phrase it.
Perfect. So I'm the scrivener here drafting our memo that all of you have to sign off on. And basically what I have so far is probably Delaware, unless you can't afford it or you want to have one of these sort of special protections with respect to control or statutory assurances that maybe you won't get entire fairness review. But that's kind of in process still. And you're maybe more skeptical. So I'm going to have to compromise between the two of you. How are you feeling so far about our memo?
I'm feeling really good. And so a few preliminary comments. I represent the Capitol, okay? I'm a shareholder lawyer. Every single case that the judges talked about at the prior panel are my cases, okay? All of them. So that's the lens that I'm looking at this. I'm providing capital to your company. It's going to be a public company, and I'm going to try and decide, am I going to invest in your company? And I feel really good because last year I was doing this panel, and I was the only one who stood up for Delaware. And now, actually, the mood has shifted. Like a year ago, I was like vehemently denying Delaware, and I'm from New York, by way of Amsterdam, okay? But I was like shocked, right? And now, actually, it's good. And I think there's very good reasons why it should always be Delaware, with one limited exception. And what you're going to hear from me is sort of similar to what Christina is saying, but more from a shareholder perspective, okay? So if you just think about the numbers, right? We talked about maybe 25 companies. I saw ISS numbers saying 14 companies moving from Delaware to Nevada. That's out of 2,500. That's a trickle. Okay, Dexit was never a thing before SB 21. It's still not a thing now. It's a trickle. And there's so much energy being wasted in some ways to talk about Nevada. And Nevada has been this way since 2017. And that's when the law was changed that Christina was talking about. And earlier this year, in June or so, a study came out from Bennett and Stoltz, and they did an event study. And they looked at the value of Nevada companies before 2017 and Nevada companies after 2017. And the study is called a quasi-natural experiment. And what did these researchers find? When Nevada in 2017 reduced all accountability to their shareholders, what happened to the companies? They lost value. Their debt cost went up. They did a lot of acquisitions that were not accretive. CEOs were no longer responsible and actually accountable for anything. And in the end, it was a net decrease in value. Or, to put it differently, cost of capital went up. And so when I'm an investor, I would like to figure out, where am I going to invest? And look, one of my jobs at my firm is I represent a lot of European investors in different kinds of cases. And I get a lot of questions now. Similar to the people who are, promoting SB 21, getting questions from their clients, I get questions from my clients, large asset managers, and they say, is the US still investable with SB 21? Do we still want to invest in the United States? And I'm American, by the way, proud American. I say, absolutely, absolutely. But it is also true that the cost of capital is going up because overall accountability is going down. But to think that anybody should invest anywhere other than Delaware, there's only one exception, and this is where I give a different twist to what Christina was saying earlier. Christina made it very clear, and I agree with you, that if you're a controller, and you're a controlling stockholder, and you're trying to decide where to invest, my thesis is 99% of the time, the controller's interests are fully aligned with everybody else in the company. There is no difference. The only time is when the controller is trying to use that control to enrich themselves at the expense of the other shareholders. Private benefits of control. Okay? If you're a controller that already knows now, I'm going to take advantage, yes, go to Nevada. Okay? I had a couple of cases against Jim Dolan, right? And he went to Nevada. You know what Delaware should say about Jim Dolan? Goodbye, good riddance, we don't need you. Who needs Jim Dolan? I'm not a Knicks fan, so it's fine. And he also banned me from Madison Square Garden. But the critical point is, that's a trickle. Those are the bad actors. Delaware has always been, and this is where I 100% agree with Paul, has more than 100 years of case law that basically says, as Vice Chancellor Will very eloquently said just a moment ago, if you act in good faith and you are doing your best, the courts are not going to second guess you. And actually, in my experience as a shareholder, Delaware Chancery Court is extremely protective, especially of outside directors that are trying to do their best. And so if you are a controller who's planning to act consistent with their own fiduciary duties to basically benefit the entire enterprise, therefore themselves, thereby lowering the cost of capital, go to Delaware. There is no other choice right now. But if you're really thinking that, as a controller, I'm going to just, take advantage of my fellow shareholders, go to Nevada. And I do tell my European clients, do not invest in Nevada unless you're willing to pay an excessive premium because there is no effective legal system in Nevada. My final note on this is, I had a case in Nevada. I have a nationwide practice. I had a case there. And the controller was taking advantage of a company and front-running a corporate opportunity. I go to the first hearing. The judge says, I think the defendants, they need to create a special committee, and I have a really good friend, and that friend should really be the lawyer. I was like, oh, this is not good. And then in the middle of the case, the judge came hand in hand asking for campaign donations to us, okay? Nevada. We're not talking about some country outside our country, okay? Nevada. So the idea that Nevada is now going to create this independent legal system and judiciary that anybody should have any confidence in is a joke. I don't bring any cases to Nevada. So if you want to be safe from me, go to Nevada.
So I think for this memo, right, I was trying to think who would be getting it. So the thought is, I'd sort of view it in two different categories, maybe three, but you got your private company, late stage private, maybe looking to go public, and then your public established. Starting with the public established, looking back at the proxies for the companies that have reincorporated, I think a lot of them would compare both Delaware and Nevada law, but with the amendments, sort of that delta isn't as wide. So if you are a public company thinking about reincorporating, now with the Delaware amendments, what is the case that you're going to make to your shareholders? I think that's something that you need to run through in terms of calculus. The point about the controlling stock, I mean, that makes a lot of sense, right? They understand sort of the deal, that there aren't as many governance protections given that situation. Same thing, I would say if you're an early stage private company, and I've had this conversation with some friends that are in stealth mode at their companies, it's like they're asking, where should we incorporate? I mean, at this point, maybe Nevada. Write it out, see what happens, and then if you want to flip over to Delaware, you can. But one other thing I'll say too is for those, because I love Delaware courts, right? So from a business perspective, from a contractual perspective, to the extent that you have like the business, a business unit or business interests within a subsidiary, why not incorporate there in Delaware and then your company? I know how you probably feel about this structure, but why not incorporate at the corp level in Nevada, and then for business purposes for your U.S. business units in a Delaware entity? So
I have a fair amount for our memo now about Delaware and about Nevada. but I'd like for each of you to say something about Texas. What's up with Texas? You have clients you're advising they should go to Texas, or how should we compare Texas and Nevada in our memo?
Look, I think Texas, similar to Nevada in some ways, there have been incremental changes to the Nevada statutes that happened during this last legislature. I think Texas is trying to move in that direction of a similar sort of codified business judgment rule. I would say as a general matter, I'm not talking with anybody that is seriously considering Texas. I think Nevada really has kind of emerged as the jurisdiction, despite sort of the Musk effect that initially had companies excited, or potentially founders excited about Texas. I think most of the companies we're seeing reincorporating to Texas are actually headquartered in Texas, and there probably are benefits. I think you can get the governor's cell phone number, like, you know, there's things to happen there. But as a general matter, I don't think we're going to see. I think I do agree we're dealing with a trickle, but I do think the trickle is going to be more heavily weighted toward Nevada.
No discount for Texas.
No discount for Texas.
Either of you
Lenin's
have
not
anything
giving
to say about
anyone
Texas? And I should
discounts.
say,
Yeah.
Judge Dorfman, who is my moot court partner in law school, I apologize for that accent. That was atrocious. Do we have anything else to say about Texas?
What Christina said is consistent with that, with what I have seen and heard. Not many people looking to go to Texas, and I don't think it's a threat. I think.
I mean, I don't want to be too stereotypical about Texas, but they're very loud, but nothing is really happening.
You like the juries?
I mean, look, I'm a shareholder lawyer, I'm a plaintiff's lawyer, right? So I like going to court and interacting with the judges and with jurors. And I've said on other panels that if companies want to move to Texas because they think there's going to be less accountability, right? This is, again, ultimately about how much accountability are you willing to accept for trying to extract private benefits of control. So if you want to go to Texas for a lower level of accountability to your shareholders, I don't think you're going to find it there, right? The largest civil judgments in history, too, are both Texas juries. And so there are very significant financial consequences to those potential cases. And I like jurors. I do. You know, it's good to be in front of a crowd of people and explain to them how this particular defendant used their position to enrich themselves at the pension funds that I represent. And that's a powerful story. And then the final thing I will say about Texas is, and I've said this on other panels too, if I have a case in Texas, I know what I'm going to do very, very quickly. Maybe the first thing I will do if I have a case in Texas is I'm going to find the judge's cousin, and that's going to be my local. And so, you know, any advantages that people think about moving to Texas are not there. And look, I say it somewhat facetiously, but I'm not entirely facetious about this. I mean, if you think about what Delaware is offering, and you know, you're a venture capital community, what Delaware really is offering is a community for more mature companies, public companies, and you're entering that community, and that community has significant benefits. You know, the Secretary of State and I don't necessarily agree on SB 21. However, there's apparently, and Christina I think will confirm this, there's not a single state in the country that is more receptive to requests from corporate transaction planners to get documents and to get stuff done, and that matters, right, if you are doing a transaction. Think about the judges. We saw 3 of them. I know all of them. They know all me. Why? Because they make themselves available. How many times have you seen judges come to panels like this where they talk openly about their decisions and how they're thinking about those decisions? That is unique, right? And you get like this, what I call thick knowledge base. A networking effect has always been described as well, where people kind of know, okay, this is how the law is going to be. This is also why I've always resisted this, it's also uncertain in Delaware. It's not uncertain at all. And this community that you are all part of, it's unique. And so that's also why I'm so strongly in favor for our memo that it should be Delaware unless you're trying to extract private benefits at the expense of your shareholders.
And maybe if we can just put a pin in that for a minute. I do generally agree, right? Controlling stockholders should be and largely are aligned with all stockholders in a company. But I think if you take a look at, and I wish I had these stats at my fingertips, but if you look at dual class, founder-led controlled companies, they perform better. Historically, over time, they perform better in the market. And why is that? It's because you do have this sort of visionary founder that investors are investing in, and they understand that they are investing in some ways in a person, in a vision for the future, and the desire to do things in a bit of an unorthodox way at times, not necessarily, I would say, to their own personal benefit, but that may mean that some of these founders have 2, 3, 4 companies, and maybe it is accretive and beneficial to the stockholders of their company for those companies to be interacting. In Delaware, that is a tricky decision tree, and that's a tricky case, and if I want to attract the best directors who are concerned that they are going to have, appropriate coverage for fiduciary duty claims and understand the standard of review on those cases, I think there's an argument to be said. Some directors for those types of companies may prefer also to not necessarily be in Delaware. So I would argue, and also, frankly, the Delaware courts have said, they have taken the position post-TripAdvisor that the decision to move out of Delaware is being reviewed under business judgment. We've seen a couple of companies with controlling stockholders that have just had the controlling stockholder sort of sign a consent and send out an information statement. I would argue the better path there is to try to bring all stockholders along in that decision-making process and actually put it to a vote of stockholders, understanding that you already have the vote in hand. I think that also just sort of creates some additional protection. In the private company context, there are appraisal rights in Delaware for non-consenting holders. To date, I don't think we have seen any appraisal proceedings in the context of a redomicile transaction. But these companies are having to tell a compelling story as to why they should move out of Delaware, because there's cost of, potential claims on that decision to move if it's done by a single person. So I think just I think for the category of companies that we are talking about, I continue to believe there are lots of reasons outside of personal, self-interest that are going to take companies out of Delaware.
Okay, so we're going to have a footnote in our memo with respect to empirical claims about relative performance of controllers versus non-controllers and relative performance in some states versus others. And we're going to go to my colleague, Andrew Baker, who are you here, Baker? There he is, right there. And we're going to ask you to adjudicate this. So we're going to arbitrate and have him decide. So we're going to punt that. You said put a pin in it. We're going to put a pin in that one. But you promised earlier that we'd talk about arbitration. So I want to turn to that arbitration topic and tell us, what are you hearing? This is in the water now. Let's have a little conversation and figure out what we should put in the memo for people in this room. What should we tell them about arbitration?
Yeah, I think probably the insurance world was very focused on that, right? Because sort of going back to that comment around, what drives D&O insurance in terms of how much insurance do you buy, and a lot of it comes down to securities class action claims. And so if that's the case, if you have an arbitration provision in there, how do you model that? And again, here we go back to historical data and trends. As an insurance carrier underwriter, if a company has an arbitration provision, how do you model that, right? I think the reality at this point is that we know that it's not possible to do it in Delaware at the moment. Nevada, we've talked to, as a brokerage firm, we've talked to some folks in Nevada. The gist of it is that it's not prohibited. You could do it, but it's better to do it as a private company as opposed to public. And
sorry to interrupt, but when you say you could do it, tell everyone specifically what you're talking about.
You could put an arbitration provision into your organizational documents so that securities claims don't have to go to court to be argued. They go before an arbitrator.
And you're jumping, so jump.
I would wonder whether they would be willing to give a legal opinion on that, because my reading of the statute, it's very similar to Delaware's. The only distinction is Delaware would require at least one court in Delaware, whereas Nevada doesn't have that requirement, but it still requires a court, not an arbitration.
Yeah, and so no one has said for sure, but it sounds like they are thinking about it. But then the other challenge is, who wants to be the first mover? We've talked previously, the first time that I saw it was 2012. Carlisle put in an S1, and everybody threw up all over it. And who do I mean by everybody? News media picked it up. Al Franken came out of the woodwork and started talking about it. They pulled it out. and they went forward without an arbitration provision. Most recently, we had Intuit in 2020. You had a shareholder proposal come before in that proxy. Intuit's board said no. ISS Glass Lewis supported them. They only got 2.5% approval for that proposal, so that died. So to the extent that a company decides to go that route, more power to them. I think they're up for it's a tall order to make it justifiable, I suppose.
Anything else we should put in the memo on arbitration from any of your perspectives?
Okay, so just for everybody else to understand. So until very recently, the SEC essentially did not allow you to have a registration statement as part of your IPO if your charter or your bylaws of the company had a mandatory arbitration provision. And the new head of the SEC has come out and say, we're going to reverse that now. And if a company wants to have mandatory arbitration in its charter, we will no longer hold up the registration statement. You can go public. That's the background, and it's creating some waves. And as Paul correctly points out, currently under the law, which was actually just passed in 2025, it's not allowed with a Delaware corporation, so we'll see what happens with that. Now, as a shareholder lawyer, I have to admit that the interests of my clients are not the same as my own. Okay, I represent institutional investors who will not be pleased with these mandatory arbitration provisions at all. Because in the US, we have an opt-out system. When you think about securities class actions, you're a member of the class if you do nothing. And so as a result, at the end of the day, if there's a settlement or there's a trial and judgment, you fill out a claims form and you get paid. If now the world goes to mandatory arbitration, that obviously is going away. Right? At that point in time, there is no more class action. And so for many of my clients, that's not going to be a good thing. But that also means law of unintended consequences, that many of those clients are either going to sue or sell their claims, and you're going to have thousands of arbitrations. There is no more global release. Like when people think about plaintiffs' lawyers, the plague of us, they never think about the peace that we actually provide as well, right, through our cases. And so there's not going to be a global release anymore. And at that point in time, we're going to have arbitrations everywhere with no precedential value, right? And you know what I like about arbitrators? They will split the baby, okay? And when you think about securities class actions and the recovery rate compared to the damages, it's never 50%. And so for the lawyers, this is going to be great. But for the institutional investors, it's not. It will further increase the cost of capital of actually investing in our country, right? The capital that we need and that has made the United States the deepest, most liquid capital markets in the world, that has powered our economy. So it would be a disaster for our country. Lawyers like us will always be fine, but it would be really, really terrible for the investors and also ultimately for the economy. And I'm not even sure the companies want it, because do you really want to have 1,000 arbitrations all over the country? Because they're going to be.
I agree with that. I think it's another one of these kind of very interesting, intellectually stimulating conversations. I think once companies really flesh this out and think about it, I don't know that they are going to actually want to implement a mandatory arbitration provision. Although I definitely agree they can't do it if they're a Delaware corp, and I think it is less clear in Nevada.
Final note on this, we have written the complaint already. So the first mover we're going to have fun with.
It's coming for you.
So it sounds like we've ended up with a relatively simple one-pager here. Is there anything else that you want to put in our memo? We have a little bit less than 2 minutes left. We good?
I'll just reiterate, Delaware is the place to be because of the expert Court of Chancery, the Delaware legislature that obviously responds to what it perceives as demands of the corporate world. We saw that with SB 21 and before that, the Mullis Amendments. I think regardless of one's views of those amendments, it's safe to say that it indicates that the Delaware legislature is willing to make moves where it thinks appropriate in order to maintain Delaware's status as the place to be for incorporation. And I'll also mention the Secretary of State's office. Secretary of State is here today, the Delaware Secretary of State's office.
Where is the Delaware Secretary of State? Here? Here we go. Hello.
Thank you for being here.
Thank you for being here.
Transactional planners' needs and making sure that Delaware remains an easy place for transactional planners to incorporate and close transactions.
So I would also put a footnote in the memo. you could have a footnote, maybe we want to reincorporate later in Nevada, but I actually think that SB 21 was a self-inflicted injury for Delaware. It has increased the cost of capital. There's a Professor Talarita at Harvard, I teach his class sometimes. He did an event study and he showed that about $700 billion of value, market cap value, was erased from Delaware companies after SB 21, mostly in companies with dominant stockholders, more than 50% vote. And so I actually think that now Delaware has created a situation where other states may actually say, you know what, we're going to be more investor friendly. We're going to replicate what Delaware did. And so I would like to put a footnote in there like saying, okay, let's keep Delaware for now, but let's see what other developments are out there. It may not all be like Nevada. It may actually be going in the other direction.
I would say I think the trickle out of Delaware is going to continue. I don't think it's going to be a wave, but I think as we watch IPOs over the next several years, you're going to see a much higher percentage of dual class or controller IPOs going to Nevada.
Final word?
No discounts yet.
All right, we'll be asking you for discounts next year. Please join me in thanking our panelists.